This is the Tea on International Arbitration with Nicole Silver and Gaela Gehring Flores. Nicole Silver and I are practitioners in the field of international arbitration, and we are both chairs of two committees of the DC Bar International Law Community. Nicole is the chair of the International Investment and Finance Committee, and I of the International Dispute Resolution Committee. Not too long ago, we might have been speaking with you from our favorite conference rooms. And just in case someone is listening to this podcast in the future, it is the end of June 2020, and we are in the midst of a global pandemic. And the world, particularly the United States, is also having a deep reckoning with respect to white supremacy, racism, and police brutality. So we turn away from the conference rooms and we turn to the podcast. And what we aim to do with this podcast is to give you some bite-sized information regarding international arbitration topics of interest. It is a great pleasure today to introduce today's purveyor of hot topics, Mark Cantor. And because Mark Cantor has so much to share with us, we have divided this episode into two. So welcome to part one of our series with Mark Cantor. Quite simply, Mark Cantor is a luminary figure in the field of international disputes. He's a retired partner of Milbank, Tweed, Hadley, and McCloy, an international arbitrator in investment and commercial disputes, adjunct professor at the Georgetown University Law Center, editor-in-chief of the online journal Transnational Dispute Management, and a member of the World Bank Sanctions Board. Many of you are familiar with his work in international disputes topics through his timely and enlightening contributions to the OJIMID listserv. He is on the council of the American Arbitration Association and former chair of the DC Bar International Investment Committee and the DC Bar International Dispute Resolution Committee. So when it comes to the DC Bar committees, Nicole and I are standing in Mark's shoes. Mark has authored numerous works and is known to most in our field as the arbitrator who quite literally wrote the book on damages, entitled Valuation for Arbitration, Compensation Standards, Valuation Methods, and Expert Evidence. It is one of very precious few arbitration resources that travels with me wherever I go. There is so much more to Mark. I could talk about him all day and the great human being that he is. To find out more about his professional life and experience, please go to mark-cantor.com. We've brought Mark here today to talk about a favorite topic of his, the intersection of international dispute law and the United States Supreme Court. So Mark, on June 1st, 2020, the Supreme Court of the United States handed down its decision in GE Power versus Outokumpu stainless steel. The court upheld an appeal by GE, ruling that the New York Convention does not prevent non-signatories from enforcing arbitration agreements under principles of equitable estoppel. With this decision, the highest court in the United States overturned a decision from the 11th Circuit Court of Appeals, which had ruled that the New York Convention did not permit GE to compel ICC arbitration against a subsidiary of a Finnish stainless steel group and its insurers. So that was quite a mouthful, with some double negatives to boot. So, Mark, I was wondering if you could first give us a brief summary of this case and then explain whether and how this decision, which has significant implications for domestic arbitration and parties subject to the Federal Arbitration Act, impacts international arbitration and the interpretation of international treaties or other international laws and doctrines.
Let me begin by thanking Nicole and you for being kind enough to invite me to participate in your podcast series. Let me also thank the DC Bar communities for their willingness to host the podcast series and reach out to the international community. I think all of us who practice international law in the Washington, D.C. area, and indeed well beyond Washington, D.C., are grateful for that kind of support. Gaila, I'd also like to thank you for that overly flattering introduction. It is truly the case that my father would have enjoyed it and my mother would have believed it. Let me turn now to your question. Without going into too much detail, GE Energy Power versus Outokumpu Stainless involves a claim by the owner of a cold rolling steel mill in Alabama, Outokumpu Stainless, as successor to the original owner, ThyssenKrupp. Outokumpu entered into a prime contract with a company called Fives, or FL, to construct the facility. Fives then entered into subcontract, including subcontracts with GE Energy Power to produce motors for the mills. Those motors failed. Outokumpu, having succeeded to ThyssenKrupp, brought suit in Alabama state court against GE Energy. That was removed to federal court on diversity grounds. GE then sought to have the suit compelled into arbitration, relying upon the arbitration clause in the prime contract between Fives and Outokumpu as successor to ThyssenKrupp. The prime contract contained an ICC arbitration clause, specified Dusseldorf, Germany as the situs for the arbitration, and specified German substantive law for the dispute. GE argued that it was entitled under both the text of the prime contract, which contains unusual references to subcontractors, and under the common law doctrine of equitable estoppel, to require Outokumpu to bring that claim in arbitration rather than in the US courts. Ultimately, that dispute ended up in front of the 11th Circuit, which concluded that the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards allowed enforcement of an arbitration agreement only by the parties that actually signed the agreement. GE Energy, of course, was not a signatory to the prime contract, only to the subcontract arrangement. The 11th Circuit held that allowing GE Energy to rely on state law equitable estoppel doctrines to enforce the arbitration agreement would conflict with the convention's signatory requirement. The case then moved to the US Supreme Court. The Supreme Court reversed the 11th Circuit. Bear in mind that the Supreme Court had previously recognized under the Federal Arbitration Act that a signatory can compel a non-signatory to arbitrate under state law doctrines of equitable estoppel. So the question was, can a non-signatory compel a signatory, or does the New York Convention prevent that result by virtue of its reference to written agreement? The US Supreme Court, in a decision authored by Justice Thomas, unanimously held that the 11th Circuit should be reversed. Now, the Supreme Court had previously recognized that a signatory can employ the state law doctrine of equitable estoppel to compel a non-signatory to arbitrate. The issue here, therefore, is whether a non-signatory can compel a signatory to arbitrate, or whether the New York Convention requirement of a written agreement prevents the same result from arising as has previously arisen when a signatory is seeking to compel arbitration with a non-signatory. Primary interpretive tool used by Justice Thomas was textual. The New York Convention being silent as to the availability of doctrines for non-signatories, Justice Thomas said, silence is dispositive here, because nothing in the text of the convention can be read to otherwise prohibit the application of domestic equitable estoppel doctrines. He went on to say the interpretation of a treaty, like the interpretation of a statute, begins with its text. Text of the New York Convention does not address these points. The convention is simply silent, and in general, as he said, a matter not covered is to be treated as not covered. A principle so obvious that it seems absurd to recite it, he went on. Here, the silence was dispositive. Given that the convention was, in Justice Thomas's view, drafted against the backdrop of domestic arbitration law, it would, in his view, have been unnatural to read Article 2 of the New York Convention to displace domestic doctrines in the absence of exclusionary language. Now, you asked me, Gaila, what does that mean for our international world? First, it's noteworthy that following prior US Supreme Court jurisprudence, most famously the Medellin decision involving the International Court of Justice. The portions of Justice Thomas's opinion considering means for interpreting the New York Convention make no mention whatsoever of international law, whether customary or conventional. The court's opinion did consider as an aid to its interpretation the negotiation and drafting history of the treaty, as well as the post-ratification understanding of signatory nations. But it did not really rely on those sources. It merely noted that to some extent, they confirmed the court's own view. You can contrast that with the Vienna Convention on the Law of Treaties, which the US government considers in this area to correctly restate customary international law. And that provides the treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. Goes on to discuss what context means, goes on to discuss further that you can take into account substantive agreements, substantive practice, and relevant rules of international law applicable in the relations between the parties. And then it also authorizes supplementary means of interpretation, including the preparatory works of the treaty and the circumstances of its conclusion, in order to confirm the meaning resulting from the ordinary meaning test, or to determine the meaning when the interpretation is ambiguous or obscure or leads to a manifestly absurd or unreasonable result. Now, that is considerably more detailed than what Justice Thomas did. Arguably, what he did is consistent with the Vienna Convention, but it is clear he made no effort to look to customary international law principles to interpret an international treaty to which the United States is a party. Second, of course, this is an international dispute. And that means that the way the court addressed whether equitable estoppel might be an available doctrine is relevant to international arbitration disputes that end up in the US courts. And that means that the Court of Appeals should not have been determined whether GE Energy could enforce the arbitration clauses under equitable estoppel or which body of law governs that interpretation. Instead, the Supreme Court remanded those questions back to the Court of Appeals to give some guidance on how to deal with those questions, not substantively, but conflicts of law principles. And I'm quite sure that's going to be another question of yours when we get to it. So why don't I hand the microphone back to you?
Thanks, Mark. I do believe that Nicole has some follow-up for you.
Yeah, thank you. Mark, I've read a few articles and posts on discussion groups where you've mentioned how essential governing law is for non-signatory issues. And more specifically, you've noted that courts and arbitrators considering whether to hold a non-signatory to arbitrate must first identify by choice of law principles the applicable governing law, and then identify and apply the elements of the relevant doctrines set out by the governing law to decide the non-signatory issues. So I'm wondering why you think that this issue is so important based on this recent Supreme Court decision, and what effect, if any, it will have on international arbitration and international tribunals sitting outside the US.
Nicole, I think it is relevant and will have an impact because it introduces a large amount of uncertainty into the doctrines for non-signatories, which are generally doctrines drawn in the United States from state law, common law principles. Why do I mean that? Before this decision, US federal courts were split, some holding that we determine the elements of those common law doctrines by looking to essentially federal common law developed under the jurisprudence for the Federal Arbitration Act. That would mean a uniform set of principles to describe the elements of each of those non-signatory doctrines. In contrast, other courts have said you look to state law common law principles rather than a federal common law. Well, we have 50 states in the United States, plus Puerto Rico, plus the District of Columbia. Never forget the District of Columbia. And while many of the doctrines at issue here are familiar to all of us, in fact, there are differences among those 52 different jurisdictions in how to determine whether or not a doctrine applies. And we're not only talking about equitable estoppel as a doctrine. You'll recall that the Second Circuit in the Thompson CSF case identified at least 5 doctrines for non-signatories: incorporation by reference, assumption, agency, veil-piercing alter ego, and estoppel. There are at least 2 other doctrines often used: waiver and third-party beneficiary status. Yes, those are doctrines we find in all the 50 states and District of Columbia jurisprudence, but they're not described identically. Moreover, they're just not described identically in Puerto Rican law either. So there could consequently be 52 different results, depending on the happenstance of the forum hearing the dispute. Well, the Supreme Court was quite clear that you look to state law to determine this. Justice Thomas's court opinion agreed unanimously, and the separate concurrence by Justice Sotomayor both grounded the availability of these non-signatory doctrines in, quote, traditional principles of state law, unquote. In fact, Justice Sotomayor, in her concurrence, expressly pointed out that the elements of the doctrine of equitable estoppel differ from state to state. Now, that means the court has directed us to use a choice of law process in order to determine what law we look to determine the elements of any particular non-signatory doctrine. First, of course, you have to determine what the choice of law principle is. Most forums apply their own choice of law principles to determine what law governs an issue. And while in the context of commercial disputes, and particularly contract law, those choice of law principles are often quite similar. They are not identical. So that the choice of law principles in New York courts may be different from California courts, from Georgia courts, and etc. In the absence of mutual agreement between the disputing parties on the choice of law, most forums will usually apply a balancing test. For example, the most significant relationship test in the conflicts of law restatement. But often with presumptions, such as looking to the place of payment for loans. Those presumptions can differ from state to state, even in circumstances where the individual states accept a balancing test like the most significant relationship test. And even in arbitration, the arbitration rules we apply may contain a choice of law principle. Article 21.1 of the ICC rules, for example, contains 2 instructions. First, the parties shall be free to agree upon the rules of law to be applied by the arbitral tribunal to the merits of the dispute, freedom of contract. Second, in the absence of any such agreement, the arbitral tribunal shall apply the rules of law which it determines to be applicable. Now, that is quite a difficult test to manage. It affords a considerable amount of discretion to the arbitral tribunal. The choice of law process, therefore, is easier to describe than to apply, given the balancing tests used domestically and internationally to determine the governing law. If by definition, one of the parties is a non-signatory, then finding mutual agreement can be very hard. Applying the balancing test that is relevant if there is no mutual agreement is even harder because the factors are often quite complicated. Just use this case, GE Energy Power versus Outokumpu Stainless, as an example. Outokumpu, it's a Delaware company based in Alabama and a subsidiary of a Finnish parent. GE Energy is a French company, part of GE's worldwide enterprise with headquarters in the US. ThyssenKrupp is a US subsidiary of a German company. The prime contract specified a German arbitral situs, German substantive law. The subcontract specified arbitration in Paris instead. The motors were manufactured in France and installed and operated in Alabama. The judicial forum, a federal court in Alabama. Now, to which jurisdiction does the most significant relationship point? Does it matter that Outokumpu, as successor to ThyssenKrupp, has agreed to German law in the prime contract. Is that estoppel? Does it matter that GE wants to take advantage of the prime contract? Is that estoppel? In addition, there are going to be times where the balancing test points to the substantive law of a foreign state with an underdeveloped body of relevant law. Ruritania, for example. In those circumstances, the difficulties are magnified. There are some times where it will point to a jurisdiction that has a very different set of non-signatory doctrines than is understood in the United States. France is a good example with the group of companies doctrine. Or choice of law principles may point to a law that bars non-signatories from triggering arbitration at all. Russia, for example. Now, in the GE case, the lex arbitrae is German. Should contract formation be examined under German law? I do not know what German law has to say about non-signatory doctrine. I suggest you ask Professor Bernard Hanotea. He's coming out with a new edition of his book on these issues quite shortly.
Thanks for that enlightening commentary on the Outokumpu case. I have maybe somewhat of a controversial question. You know, I like to stir the pot a little sometimes. And that is, do you think that the US Supreme Court's decision in Outokumpu would have been different if the party seeking to enforce the arbitration agreement, to which it's not even a party, wasn't a US entity? In other words, do you think that the US Supreme Court was showing a little bit of favoritism towards a US entity? And if a non-US entity was trying to do what GE was doing, the decision may have come out differently?
No, Gaela, I don't. First, I really doubt that those kind of motivations drive the members of the Supreme Court. Second, even if they did, I think other motivations would have been stronger. First, the jurisprudence of the Supreme Court with respect to arbitration has been fairly pro-arbitration, with only a few exceptions, such as the new prime decision. Whether or not the non-signatory is a US entity or a foreign entity, the decision in Outokumpu is essentially pro-arbitration. It expands the available disputes that can go into arbitration. And I would not be surprised to see that approach continue for the court. Second, if instead of the actual circumstances, the parties seeking to move the matter into arbitration had been a non-US company, that would have removed a dispute from the US courts. And one could speculate that reducing the burden on US courts of disputes that are largely foreign in character would be something that might motivate some judges. So for both of those reasons, if those kinds of motivations were relevant, they might counsel to the same result as we have in the actual case.
Thanks so much, Mark. This is some really enlightening information on these cases. Because you have such extraordinarily helpful information to give, we've decided to break our podcast with you into two. So this concludes part one of the Tea on International Arbitration with Mark Cantor. Please look forward to part two with Mark Cantor coming out soon. If you liked this episode or others, please tell a friend about it and subscribe to the Tea on International Arbitration at anchor.fm/DCBarT.